Let's take a look at harassment by managers. When someone whose position allows him or her to speak and act for the company engages in harassment, the company is liable for the harassment. This is true regardless of the type of harassment. Vicarious liability means that if the illegal acts, in this case harassment, occurred, legal responsibility for damages is unconditionally placed with the employing organization. The organization cannot avoid liability by showing that harassment was contrary to its policies or in spite of its best efforts for prevention. For managers and supervisors other than top officers, the liability story is a bit more complicated. Indeed, identifying who is a supervisor can be tricky, as job titles do not always capture the fine gradations of authority attached to positions, and there's no uniform legal definition of what constitutes supervisory status. For purposes of assigning liability to employers in harassment cases, supervisors are individuals who exercise immediately or successively higher level authority over victims of harassment. The nature that authority is such that they have the power to make significant change in employment status, such as hiring, firing, failing to promote, reassignment, with significantly different responsibilities, or a change in benefit. Vicarious liability is the norm in discrimination cases. If a manager discriminates older workers when deciding who to lay off, the company is liable for that discrimination, regardless of whether top managers were aware of the practice or encouraged it in any way. In harassment cases, the general rule of vicarious liability for discrimination is adhered to when the harassment results in a tangible employment action. If a manager or supervisor uses the decision-making authority that's been conferred to them to try to exact sexual favors and then makes employment decisions accordingly, the employer is vicariously liable. Even though the supervisor or manager is likely acting outside the scope of his employment in doing so, he is still an agent of the employer and aided in carrying out the harassment by being given authority to make employment decisions. Often, managers and supervisors engage in conduct that creates hostile environments for employees they manage but does not result in tangible employment action. In such cases, employers can avoid vicarious liability by establishing both prongs of the following affirmative defense. First, the employer exercised reasonable care to prevent and correct promptly any harassment. Second, the plaintiff unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or avoided harm otherwise. Whether reasonable care to prevent harassment was exercised depends first and foremost on the existence of a sound harassment policy and complaint procedure. Absent a legally adequate policy prohibiting harassment and identifying a set of actors to whom harassment complaints can be made, an employer will almost certainly be unable to establish an affirmative defense. Reasonable care must be taken not only to prevent harassment, but also to correct any harassment that nonetheless occurs. In general, employers need to show that they acted promptly in responding to employee complaints, conducted effective investigations, and took steps reasonably calculated to remedy harassment and prevent future incidents. To prevail using the affirmative defense, employers must not only take the necessary preventative and corrective measures, but also show that their employees unreasonably failed to take advantage of these measures. The most common, though not the only reason for finding that an employee has acted unreasonably is a delay in reporting harassment. Courts have clearly placed the burden on employees experiencing harassment to come forward quickly and to use their employer's established reporting mechanisms.